Right now, politicians across the country are scrambling to redraw their congressional maps just months before a major midterm election. This rush is the direct result of a single Supreme Court decision that altered the legal requirements for drawing American voting districts. In April 2026, the court handed down its ruling in Louisiana v. Callais. That decision struck down the final major protection of the Voting Rights Act of 1965. This ruling provides a legal method to erase the political power of millions of voters without touching a single ballot. Historically, Section 2 of the Voting Rights Act functioned as a strict mathematical guardrail. It legally blocked mapmakers from drawing district lines that diluted the voting strength of minority communities. For nearly 60 years, this core provision stood as the primary defense line for civil rights in the electoral process. To understand how cases like Callais affect your representation, make sure to subscribe and hit the bell so we can keep untangling these complex legal shifts together. To grasp how the map of America is being redrawn today, we have to look through the lens of the mapmakers themselves and the specific algorithms they use to draw the lines. This animation shows the two primary techniques of geographic voter manipulation: packing and cracking. Packing concentrates a targeted group of voters into a single district, while cracking dilutes that same group across multiple districts so they can never form a majority. For decades, the legal defense against these tactics was the Gingell's framework, commonly known as the effects test. Under the effects test, it did not matter if a mapmaker admitted to discriminatory intent. If the resulting map mathematically diluted minority votes, it violated Section 2 and had to be redrawn. Evaluating effects rather than intent is critical. Modern mapmakers often hide their objectives inside complex, highly efficient algorithms rather than leaving a paper trail. A Republican redistricting strategist named Thomas Hoffeller pioneered the use of massive datasets to engineer these electoral advantages. When Hoffeller's hard drives were discovered after his death, they revealed spreadsheets tracking millions of citizens, sorted by race, age, and voting status. These files contained highly specific demographic targets, such as the historically black campus of North Carolina A&T State University. Hoffeller used that granular racial data to draw a boundary line directly through the middle of the campus. This split the student body into two separate Republican-controlled districts, neutralizing their collective voting power. With modern computers running millions of simulations, racial targeting is difficult to detect. Without a mathematical benchmark like the effects test to catch the anomaly, the map appears to follow neutral geography. This brings us back to the 2026 Louisiana v. Callais case. Louisiana attempted to draw a second majority black district to comply with the Voting Rights Act and remedy past discrimination. Opponents challenged the map, asking the Supreme Court if taking race into account to fix racial discrimination violates the Constitution's promise of equal protection. The court ruled that using racial data to construct districts, even to correct proven discrimination, is an unconstitutional racial classification under the 14th Amendment. This creates a legal paradox. Political operatives can use computer algorithms and demographic data to target and dilute minority voters, but the law is now constitutionally banned from using that same data to fix the resulting maps. The reaction was immediate. States like Florida passed new partisan gerrymanders hours after the Callais decision. The impact on representation is direct. Without Section 2 protections, up to 30% of the Congressional Black Caucus could lose their seats. Because the legal standard has shifted, challenging these new boundaries in court is now significantly more difficult. The upcoming midterms will be shaped by these new, unchecked gerrymanders. The Supreme Court has effectively removed the federal guardrails previously used to oversee state redistricting. Callais is the result of a decades-long strategic campaign by conservative legal groups to dismantle the Voting Rights Act piece by piece. The legal roadmap moved from gutting federal preclearance in 2013 to restricting voting access in 2021, and finally targeting the maps themselves in 2026. In her dissent, Justice Elena Kagan labeled the Callais decision as the now completed demolition of the Voting Rights Act. The Voting Rights Act is now effectively a ghost. The algorithms have been unleashed, the maps have been redrawn, and the only question remaining is whose voice will be left in American democracy.